Let's go to London, talk to Sabah al-Mukhtar from the Arab Lawyers Association. Mr. al-Mukhtar, good to have you on the programme. Let's get to a point that was made at the end of Charles Stratford's report, first of all, that if these confessions were extracted...
Yeah, hello, I can hear you.
If these confessions were extracted under duress, then they wouldn't have much credibility. But would they still be admissible in court?
Unfortunately, the situation in Bahrain, yes, they will be admissible in court because the penal code of Bahrain does not actually, it prohibits torture, but the criminal procedure code does not say anything about it. The constitution prohibits torture as well. However, we have the biggest problem is that the Emir in 2001 issued an amnesty decree for people who have committed crimes, but in the next year he issued decree 56 of 2002, whereby he included the torturers in the amnesty. Therefore, if you are tortured, you have an amnesty, and the torturer has an amnesty. Therefore, the torturers in Bahrain at the present moment are immune from prosecution. Many cases have been put before the courts in Bahrain, but they failed because the court would rely on Decree 56 of 2003, that they cannot be asked for the crimes they have committed.
So how independent is the judiciary? Would it be able to make its own mind up when it came to the background to these confessions, or would it follow what it was told to do?
Well, there is a presumption that the judiciary is independent, but if the legislation ties the hand of the judiciary, in this case the judiciary cannot do very much. So as soon as any torturer is put before a court, the defense lawyer will say Law 56 of 2002 makes him immune from prosecution, therefore the court has to adhere by that one. So the problem is with the legislation more than it is with the court. Obviously, we don't know, no cases have been actually tried or tested in the courts, so we cannot really say very much about it. But I think that the judiciary in Bahrain would be just as bad as the other third world countries, generally speaking. But nowadays we have even in...
I'm simply going to say, if we hear that somebody is going to be put before a military court as opposed to a civilian court, what should we read into the likely outcome of those proceedings, depending on which jurisdiction it's in?
Well, in this case, the putting somebody before a military court, that would enable the government to sentence them for anything. It overrides the procedures, it overrides the legislation, it relies on the emergency and security situation, therefore they can penalize them, and at the same time they don't have the same rights in defense, they don't have the presence, it's not in public. There are all the other discrepancies in addition to the emergency laws which are applied. But we have a problem. Both of this instance is against the Convention Against Torture, which is an international convention, but nowadays we have even the USA admitting admissions under torture, so they are setting a bad precedence for Bahrain and others.
Appreciate your time. Thank you very much indeed. Sabah al-Mukhtar.